Hey, saw a question recently came through the door about how does one afford a Social Security disability attorney if they are poor enough to be at most eligible for SSI? Um, the answer is actually true for a lot of people who are unable to work due to medical impairments, who actually are insured for Social Security disability also. So this response isn't just for SSI people, but for sure, we know that a person who's eligible for SSI financially would be generally quite low in income for sure, and generally low in countable assets. So while it could be that they have a house that they live in that could be quite valuable, and that's not going to stop SSI, thankfully. Other than that, and perhaps a car, their income is quite low and their assets are not ones that would readily be turned into cash that they could use to pay their bills and their basic support. So, okay, it is my pleasure to share that by and large, most SSI attorneys, and I would say that most are considered SSD attorneys, and many of the SSD attorneys will take SSI cases. Not all will take SSI cases, but I'd say certainly many, maybe most of us do. So we don't differentiate on that aspect. And there are reasons why some won't take them. And it's usually going to come out to be what the fee might end up not, more likely to not be. But so it is definitely my honor to say that, and my thrill to say most lawyers that do take it do not require a retainer. They are allowed to charge a retainer, if that's what their requirement is. They can do so as long as it's, put aside into trust, and they can't charge it as a bill to the claimant unless and until the SSA gives written approval to so charge, in which case they can then take it out of their retainer account and pay themselves. And if anything is left over that the SSA did not approve, they'd have to send it back to the claimant. But most don't do that. Fortunately, this system is, in a nutshell, designed so that people can access advocates, and particularly attorney advocates, should they want to, without a retainer. So the general deal is that you sign all the necessary paperwork that the SSA requires to effectuate this. But when the case is won, and if it's won, and only if it's won, generally, that's called contingent. Contingent on winning is when there's going to be a fee generated. Contingent on winning. And if the case is won, the SSA, and of course, everybody else involved, including yourself or your attorney or your non-attorney rep, will be looking towards, from the date the SSA says you are disabled and eligible for SSI benefits, to the present, meaning the time that you win and that you've been, determined disabled from some time between now and going back. That between now and going back period would constitute the months of benefits that would make up the back benefits. Okay, so let's say it is, I'm going to round it off to 900, even though in 2023, the SSI maximum benefit is 914. Let's just say 900 to make it easy. Let's say you have 5 months of back benefits. So you either applied 5 months ago and said you were already disabled, and they agreed that you were at least disabled as of the date you applied, or you applied before that, but they didn't agree with it going back as far as when you applied, and they found that you were indeed disabled, but at some later date, it was evident to them based on your medical records. Because as you know from some of my videos, treat, you need to build up those medical records if you plan on winning. So if it's 5 months ago that you are found disabled and have an application pending, whether it was pending before that or not, but at least as of the date that you're found disabled, you're going to get paid those 5 months of back benefits. And if it's $900 a month that you're eligible for, that would be $4,500 in back benefits. So the representative under the SSA rules, they will calculate 25% of those back benefits. And this is if everybody's using like the standard fee agreement that the SSA has already approved. In fact, they have issued a standard form themselves, even though it's not mandatory to use. Many of us have chosen to use it for various reasons. So 25% of 4,500 is going to be somewhere around what, 1,100 and something. That's going to be the attorney fee. And the SSA is generally going to pay it straight away and pay you the balance. So the 4,500 minus the attorney fee is going to be what is sent to you. I should add that sometimes when it's SSI, depending on the size of your back benefit, they may divide it into 3 payments to you. This comes as a shock to some people, and they find it frustrating, but it's done to protect you because, as you recall, you can't have more than $2,000 in countable assets and still have your SSI. Now, the SSI back benefits, they give you significantly more time, like 9 months to spend them down, as opposed to getting let's say you got $25,000 worth of back benefits and you had to spend it all in 1 month. It would be wasteful, right? You'd probably have to waste it. So they do give you 9 months, but to make that easier, so people still aren't having to send it where they really shouldn't, where they can think and spend it smartly, because there's smarter ways to use that money and still remain on SSI versus, going on a vacation around the world, So that's why they divvy it up. So you'd get like 1/3 when you win, 1/3 6 months later, and the remaining 1/3 at the end. And then you still have to, spend that down eventually. So you're going to want to look at those rules when you get there, make sure you look that up. But in any event, the attorney fee should be pulled out. And generally it's going to be that 25% of back benefits if you have back benefits. Now, if you don't have back benefits, because let's say they decided you were not disabled when you said you were, there wasn't sufficient medical evidence. They're not saying they don't believe you, but they can't award you based on a belief. They have to substantiate it with the medical evidence you have provided, or you have given them enough information so they can go obtain those records on your behalf to make the decision. So when that happens, and you only win as of, say, 2 weeks ago, they tell you, oh, we think you won, but you only won last month. Then there's no back benefits to which they could pay the attorney or the attorney rep. Now, the attorney or the rep has the opportunity to submit a fee petition saying, yeah, I understand there's no back benefits, but I did the work. So here's the work I did. Can you, SSA, approve some sort of fee? Here's my billable hours. Here's my rate. Here's what the total would be. Would you approve that? Or sometimes, there's no reason why attorneys can't say, well, it comes to this amount for all the work I did, but I only want to charge the person X amount. Can you approve, despite saying all I've done, can you just approve so-and-so amount? I've done that many times. I actually don't do that on SSI people. I actually waive my fee. But if there's no back benefits, not otherwise, only because I don't really want to see a person on SSI with a payment plan to me. It would kind of defeat my whole good warm fuzzy feeling about the whole thing. But by and large, you can, I think most attorneys, if they do a fee petition on an SSI case, probably allow you a payment plan because they know there's no other way to do it. So, whatever works, right? But, rest easy then, because generally, I'm going to throw some weird number out there. Let's just say it's like 98%. It might not be quite that high, but to me, it's high anyway, in my experience. And I'm just throwing that number out there just to explain that it's high, but I haven't actually done the math. Okay, so don't hold me to it. There is always back benefits. Now, if for me in particular, if the back benefits are very low, like let's say you have 1 month of back benefits, so there's $250 going to the lawyer, that's just what I accept. That's just like, you get you get the cases that pay pay your way, and then some you do just do the work anyway, and be happy for the successful outcome for your client. That is all good and fine. If you might have a lawyer who will say, well, that is really insufficient. I have people to pay, I have to pay staff, and where's that going to come from? They won't do it that way. And they can still do a fee petition, even with the low amount. They can ask for a fee increase. By the way, the SSA gets to decide that fee on a fee petition, and they could flat out say no. I have reason to believe, although there's nothing in here, I don't have anything to cite to on this. I do have reason to believe that the SSA, when they're looking at fee petitions, they don't just look at the work done and the billable hour, which, attorneys are going to all vary in their prices. They look to see, well, was that if it was like sending out a carbon copy of something, that's not necessarily attorney required work. That's more like a secretarial work or a paralegal work. And they won't be expecting probably someone to charge an attorney rate for doing that. So that those kind of things, if the fee petition isn't like differentiating, could result in a lower fee than what was requested. And they also, I think, this is some scuttlebutt I'd heard a long time ago. So like I said, I don't have anything on hand to show you. If I do find it, I'll post it below. But I believe the SSA, when they're deciding on a fee petition, look to the benefits, A, whether back benefits, B, even if there's not, what is the benefit rate of the individual? Obviously, if it's SSI, they have next to nothing. So for that reason, I'm like, no fee. But for somebody else, they could have a, $3,500 a month Social Security disability benefit, or they could have a $500 a month benefit. So it really depends. And I think the SSA takes it into account when they decide whether they're going to, what kind of fee they're going to provide the attorney. And then, of course, it's between the attorney and the non-attorney rep and the claimant who they help prevail to get that paid. So some people will allow for a payment plan. I can't even imagine not. I haven't spoken to anyone who doesn't. And that's how it can get paid. I don't encourage anyone to not pay their bill. I'm sure it happens though. So nobody really likes fee petition, particularly if it has to be paid later by the claimant. It's just not a good, nice feeling. We all want to walk away having prevailed, done a great job, and the bill is paid and the claimant has nothing to worry about. They have no bill hanging over their head. That's one of the things I love about the SSA system and how they withhold and make sure that's done. Usually it's done right, not necessarily always, but usually. But I think it takes a lot of relief off of, prevailing claimants' minds too. Like it's hard to cut a check when you're just finally getting money in and you get this big check and now you have to give part of it. But the good thing is it's only a small portion. So anyway, that is it. There is no reason due to cost to not get an attorney or a non-attorney rep handling your case. You don't have to come up with a retainer. The money you get is going to be, quote, found money in a sense. And there's, by and large, I believe, a huge difference in prevail rates when someone has an attorney rep. I just do. Maybe it's because we get a lot that didn't, and we have to redo things for them, and then we prevail. Can't tell you, there's so many different variables, but you get it at no cost. I think it's kind of a no-brainer. And it's, what do they say? Penny wise, pound foolish, perhaps, to not do it. I do understand the desire and the idea that some have to do it on their own. And obviously some are going to prevail on their own, for sure. Even on initial, just that's not going to be most people. So, you just want to maybe be a little smarter about it, particularly if winning now versus later is important. And remember, if you lose now, all the way through, you just lost all those back benefits because you did it yourself. Whereas maybe if you had an experienced representative telling you what to do and doing all the hard work for you, and the legal aspects of it, maybe you would have won then. And that could be the difference of tens and tens of thousands of dollars in your pocket. It can also be the difference between never winning, because sometimes your first and only application is the only one you can have. So if you fail it, you don't get to try again. And that was it. And you used it all up. So anyway, things to look at. That last part about it being your last chance, that has to do with your DLI, date last insured. So I could post something about that if you want. I mean, I have a video on it. I'll try to put the link down yonder if I can remember to do that when this goes up. All righty. I hope everyone's having a great night. Hope that gives some ease of mind when you think about whether you can get an attorney or not. You absolutely can. The only thing that might be stopping you, preventing you, is if you don't have strong medicals that are showing that there is something to fight for yet. You know, if you're not treating and you don't have specialists and you're not treating for many serious, one or more serious issues that you claim prevent you from working at all the jobs out there. All right. That's enough for tonight. Thanks, guys. And I'll talk to you next time. Bye-bye.